are those words recording in progress,
Mhm.
which means we have started on a quite a sunny evening, actually. I don't know if it's sunny everywhere else. It's very definitely sunny here. I was sitting in the garden, feeding my fish, playing
Yeah,
with my dog before we
I
had
thought
this.
when you're
That's
in
quite
London,
cool.
which is
Like a perfect English gentleman. All I need to do is get a shotgun out and shoot a couple of birds. Sorry, probably if anyone's there. But anyway, so that was nice. Not the heron though. Can't shoot a heron. Even though he keeps trying to eat my fish. So, good evening, ladies and gentlemen. Thank you for joining us on this evening. And well, here we go. I suppose we've got Sarah, who you may know, and you're Andy, who you probably know as well. If anything, you probably know Sarah better than us. So, what we normally do, Sarah, because you've done these for us so many times, and we thank you so much, is that we effectively have a little bit of a preamble for a couple of minutes, and then we always like to start promptly, so as that we reward the punctual. And I can see we've got a fair few people in already, which is lovely. And then people will join in afterwards. So, how have you been?
Good, thank you. Incredibly busy because, and I might get even busier now that we've got a new Prime Minister
Oh, yeah, yeah,
with all
yeah.
the changes in the employment legislation. So, yeah, I mean, there's been a lot of changes this year, and there's still more on the cards to come. So, I think any employment and HR solicitor is incredibly busy at the moment.
Yeah, some of the changes are. I know that I think we did one with you in, was it maybe April or
Yes.
March or so? And those things that were due to happen, and it's
mm,
Mhm.
quite interesting, isn't it? Because they're not necessarily massive great things, but they sort of are, if that makes sense.
Yeah.
When the right whatever it was, I can't remember. There was something you said that I genuinely can't remember, but it was like, oh wow, if you get that wrong, that's going to be
Yeah.
very expensive for you.
I mean, yeah, hugely. I mean, t tonight's webinar is not about all the changes because we could obviously speak for hours
Mm.
about the April changes and the October changes that are coming in. But for any small to medium enterprise, the changes in legislation are having a huge effect on how you run your business and your team because it's impacting businesses financially and also in the way that they deal with their team members. And I think tonight's webinar, which thank you for organising, about probation, performance and termination is really relevant because actually, as practice owners and managers, we're really going to have to understand how to use our probationary periods, how to deal with performance or underperformance, and how to let go of the team members that don't fit with
Mm.
our teams.
I tell you what, that's a perfect introduction to your
you've introduced
webinar, isn't it?
yourself.
I couldn't say anything better. So, Sarah, we will, as always, blank ourselves out, but we are still here. So, if anything happens, give us a shout. And over to you, really.
Thank you so much.
Yeah.
Thank
Cheers,
you.
and we'll see you shortly.
See you soon. What I would say to people that are on to this evening's webinar is that please do ask any questions that are relevant by putting them in the question and answer box or the chat box or towards the end of the webinar, we can you can ask questions, because I really do want you to leave this evening with any answers to any queries you may have, and I think that's really important because what I am going to do is talk about my experiences with my clients and what I advise on. But there may be something specific that you would like me to mention, and I'm more than happy to go into that issue with you. So this is me. I am a director and co-owner of Buxton Coat Solicitors. So I know what it's like to run a small business. We employ 22 members of staff, and I am the head of employment and HR. But we also do buying, selling, litigation, and regulatory. So we are there to help you. So any of those issues we will cover off. But my specialism is employment and HR, and that's what we will be speaking about this evening. So performance. What do we mean when we talk about performance? I like to separate performance into two categories. The first of these is performance in terms of attitude. values, how we work together, whether that person is aligned, whether we have strands in common with that person, and whether they understand what we're working towards. And I would say that that is your values. So each business really needs to look and start with having a vision whereby they take from that vision their values. And that's so important to try and manage performance in terms of attitude. Once you've got those visions and that value in place, that should feed into your team members. So it's really important that you do publicize your vision and your values so that we deter people that do not fit with us from applying for jobs. Because what we don't want are team members that are not aligned with our culture. So when we talk about performance with attitude, it starts during the recruitment process. And I would advise you to really think about putting out there, when you're looking at recruiting, your vision and the values of your business. So, for example, you may present these on your website. You may provide a booklet to everybody that applies for the job. You may be having these on your wall in reception. It may be something that you send in an email to potential applicants, because hopefully when they read your vision and they read your values and what's important to you in your business, if they're not aligned with those, they will deselect and you will never employ them. And that is going to become more important as we go through this evening's webinar. So if we can get rid of those people right at the outset who are not aligned with us in terms of our attitude and our values, it really does make your job easier, because it's not great having that bad apple within the team. It does upset the team and really affects morale, and it is quite difficult to dismiss a team member. So let's not employ them in the first place, and let's see if we can let's see if they deselect themselves from joining the team by really pushing our values out there. So the other type of performance is skill, and this is measurable. So skill in terms of performance is much easier to deal with, because ultimately you will set out the skill or the required performance level in a job description. So this job description is a very important document. Now, I know many dental practices will have a job description. They will have the employee sign it on day one as part of the induction process, put it in their personnel file, and they'll never see it again. The job description, just like your vision and values, is a living document that should change and evolve with the employment relationship and as the business changes. So it's really important that this job description is used on one-to-ones, appraisals, every time there's a pay rise or somebody asks for more money. You get the job description out and you look at what can be done or how that can be amended to achieve the objectives of the employee and of the business. The job description should be presented again during the recruitment process. So don't wait until somebody joins the team and then provide them with that job description during the induction process. Make sure that it's provided during the recruitment process so that if the applicant cannot reach the skill in that job description, then they'll deselect and won't apply for that job. Now, sometimes with job descriptions, it may be the case that we can train people up to get to a certain level, and we can make that, again, very clear in the job description, training provided. However, the starting point is the skill that you require. And quite often with performance, whether it's value-driven performance, so attitude, or whether it's skill performance, what we fail to do as employers and managers is set out that expectation. And this is what we're trying to do at this early stage. So during the recruitment process, we're really trying to set out what our expectations are. Because quite often people will come to me about underperformance of a team member and they are frustrated with that team member because they don't have the right attitude or they don't have the right skill, but we've never actually set out the requirements that we need. And this is why this job description and making sure that your vision and your values is very clear to any applicant and new employee, so that we're setting the example. Now, what I would say is that when you are doing the job description, it's very important to use non-descriptive language. So we need to make sure that it's skill-based rather than descriptive. So, for example, there have been numerous cases where individuals have brought discrimination claims against an employer because they've used language within the job description which was found to be discriminatory. I'll give you a couple of examples here. The first of these, which we often use within the dental team, is to describe somebody as a senior nurse. If you put in the job description that you require a senior nurse, that may be found to be age discrimination because the word senior implies that you would like somebody who's older. What you're actually requiring is a nurse of a certain post-qualified experience, and that's very important. There was also a business in Manchester where they were taken to the employment tribunal because in their job description, they described the skill that was required was for somebody to be bubbly. They wanted a bubbly receptionist. A man saw this job description, job advertisement, and he took the business to an employment tribunal. He said that the word bubbly implied that they only wanted a woman for that job role because you wouldn't use the word bubbly to describe a man. And he won his case. So we do have to be careful with the requirements and the standard that we're setting. But what you will find is that these documents are becoming more important, and you'll realise because we've got a change in the law coming up. And the change in the law is in respect of unfair dismissal. So currently, an employee has to have 2 years continuous service before they can make an unfair dismissal claim. That's not to say that in that first 2 years of employment, an employee cannot make a claim. There are 74 other types of claim an employee can make in that first 2 years of service. But currently, if you have an employee who's been with you for 2 years or more, you have to go through a fair procedure and have a fair reason for the dismissal before you can bring their employment to an end. And I am going to go into this in more detail about termination and how we do let the team member go if they're not right for the team. What's happened is that as of the 1st of January 2027, the time period whereby somebody needs to be employed to bring an unfair dismissal claim is being reduced from 2 years to 6 months. So what that means is that anybody who you are recruiting now, if they are terminated, their employment is brought to an end after 6 months service, They will be able to make an unfair dismissal claim if you don't follow a fair procedure or have a fair reason to do so. So, what do we do about this? Well, we really need to start using this management tool called a probationary period. It's not set by statute, the period of time that we have to have as a probationary period. But my advice is that most businesses should be making their probationary periods 3 months. That's because if we get close to or near to that 6 month service and we need to let them go, the risk of an unfair dismissal claim increases. So, what this does mean is that any contracts that you're putting in place now, you'll need to review your probationary periods and we need to set them at 3 months. We also need to use that probationary period. And what I mean by using the probationary period is actually having good conversations with the employee on a weekly basis about whether they are hitting the standard required of them. And that standard is in the job description. You've got that document which you can both look at together for skill. And for your values and vision, you have your culture booklet. So, or wherever you place your vision and your values, it may be in your staff handbook, or it may be, like I say, you may have a separate booklet regarding your culture. Then, if it's not right, your contract will give you the right to bring the employment to an end. Again, it's not completely risk-free because there are other claims an employee can make during the probationary period. But the biggest claim, the most claims that we see, and the claims where we've had an uplift of 74% on last year is unfair dismissal. So we just need to be really careful that we're using the probationary periods effectively. Now, to know in the probationary period, the employee still has statutory rights. So they still have a right to statutory sick pay. They still have the right to bring a flexible working request. They still have the right to notice as per their contract. So just because they're in their probationary period doesn't mean that they don't have employment protection. So if they're not performing, and this would be relevant for employees no matter what their length of service is, what we always advise is that you use a performance improvement plan. And again, this can be used for skill or it can be used for values. Usually, when it comes to values, what I would say to clients is that if they are not working and don't have your values and don't have the right attitude, I would advise clients to fire them quick. Now, don't get me wrong, there's always a procedure to go through. So we would make sure that it's done in accordance with the legislation, and we would make sure that you exercise the probationary period correctly, because usually with attitude, it's very hard to change. They're not part of your team, they're not part of your culture. Let them go quickly. I think within a 3 month probationary period, if somebody hasn't shown you that they are part of the team and aligned with your team, then you should let them go. With skill, you can try and improve skill. So we can provide training. And this is when a performance improvement plan really comes into its own. And hopefully we can use this in the probationary period. Sometimes we do use it when they've been with us for a substantial period of time. But what you do need to be aware of is whether there's any underlying issues, because usually if somebody's been performing and then all of a sudden they start underperforming, there's usually something else going on, which we need to get to the bottom of. And those are the people that become high risk, because you should be aware, or your alarm bell should start going off, that there's something more required, that it's not this person's character. They usually can perform. So why all of a sudden are they underperforming? And I'll give you an example of this. Bon Marché, who are a clothing retail outlet, they had an employee who was employed for 37 years. She performed relatively well during that period. She'd never been on a performance improvement plan. They did introduce iPads onto the shop floor, so that they could check the stock. She couldn't get to grips with the iPad, and her line manager called her a dinosaur, and also said that she was struggling to get to grips with it, and that she was underperforming. She went off work with stress, and actually, she actually said that she had brain fog, and that this is why she couldn't get to grips with the iPad. And she took Bon Marché to the employment tribunal, and she was awarded just over £28,000 in compensation, because actually the underlying reason for her underperformance was related to the menopause. And although the menopause in itself is not a protected characteristic, she did bring the claim under sex and age discrimination. And if you want to check your protected characteristics, these should all be set out in your equality and diversity policy, that you have in your staff handbook. Usually you'll find it there. So we do need to dig a little bit deeper. And yes, he shouldn't have used that banter. And it's important that when somebody's underperforming, that we do avoid jokes and look as to whether anybody needs any adjustments in place. But after 37 years of service, the tribunal said that they should have been aware that there was something underlying there. So let's say there's nothing underlying, or we're in those early days where we are trying to improve somebody's performance. The performance improvement plan is a really good document. It minutes the conversations and where the underperformance is lying, to enable you to have proof of why maybe this person's employment eventually comes to an end if we can't get them to improve. So really important document. It should set out the reason why they need to be on a performance improvement plan. It should set out the standard, the objectives, and the consequences. So, for example, if we don't see an improvement within 4 weeks, we can keep you on a performance improvement plan, or it may result in the termination of your employment. Now, when we look at putting the objectives in the performance improvement plan, we always try and make these SMART objectives. So specific, measurable, achievable, relevant, and with a time scale. So that's really important, that we're giving the employee very strict guidelines in terms of what we want to see and when we want to see that objective reached by. So PIPs, as they're called in their short form, very important documentation that you should use when somebody's underperforming. So employment contracts, the foundation of any good employment relationship is the employment contract. It needs to be kept up to date. And as we said at the top of the webinar, if you haven't updated it since the 6th of April, all employment contracts will need updating, because there was huge changes when it came to sick pay. But also, you will need to change probationary periods, and anything where there's a change in legislation, you are able to change them in the contracts with ease. You just need to explain to the employee that there have been changes in legislation, and as a responsible employer, you're keeping those contracts up to date. Now, each dental practice will have their own bespoke contracts in place because each dental practice is run differently. A lot of disputes I see are where a template has been downloaded, somebody's tried to fill it in, and they've done it incorrectly. So, for example, if we take the probationary period, I've seen contracts where it's a contractual provision that you have to state in writing that somebody's been successful when it comes to succeeding with their probationary period. Now, if you don't put that in writing, you could end up being in breach of contract. I've seen employment contracts where the name of the employer is wrong because it's not the name of the dental practice. It is you as the sole proprietor, your partnership, your limited company, depending on your legal entity. But I've seen many where the name of the dental practice will be taken and put down as the employer. These types of mistakes are costly, and you can be fined at the employment tribunal if you get them wrong. So it's really important that you keep your employment contracts up to date and you make sure that they are fit for purpose, that they suit your practice. No two practices are the same. And as I said, you will definitely need to be looking at your employment contracts now with probationary periods, the changes in April. And also, I've been advising a lot of clients to consider notice periods because the dental market when it comes to recruitment is not easy. So actually you probably need a longer notice period in terms of when people are going to leave you so that you're able to recruit. So if you've still got notice periods of 4 weeks, I would say that that is not the norm anymore. Most employment contracts for the dental team will have notice periods of 8 or even 3 months. So again, maybe an opportunity for you to bring those up to date. So as I said, changing contracts is relatively easy, especially if you've got people who are aligned with your vision and your values because they understand why you need to change the contracts. But also, with all the legislative changes, you do need to bring these up to date. Now, worst case scenario is that you unilaterally need to enforce a change. We would always advise that you stay away from having to enforce a change on your team. It should be done by explaining, making sure that they understand, because in my experience, most employment contracts are not signed because the employee doesn't understand what's been changed, and they get scared that they're signing up to something that they don't understand. So it's really important that you have good dialogue with your team members when you're handing out new contracts. So, termination. We hope we never have to get to this point because it's so high risk for businesses. The recruitment process really needs to be refined in terms of having a recruitment policy in place, making sure that the team who are interviewing applicants have been trained in how to how to interview. There is a skill involved there. Making sure that you've made it very clear before they even apply for the job what your expectations are and how your practice runs. Now, the reason why termination is so high risk is because if you do it incorrectly in terms of the procedure or the reason for the termination, you can end up in the employment tribunal. And this is where we want to stay away from. Yes, we have employment and HR legislation in place to ensure that we have a very happy and profitable team. And we want to ensure that we retain the team and then we get the right people on board. But sometimes we do have to let them go. We all make mistakes. In my time, we've let lots of our team go if they've not been right for our team, because it's better to let them go rather than try and change people that don't have your vision or your values or don't have the skill. So it is there, termination, for you to use. And I would say don't be scared of it as long as you're taking advice. However, we should try and stay away from the tribunal. So we need to make sure that we do it correctly. And the reason we need to stay away from the employment tribunal is because it is incredibly time consuming. So at the moment, we are not getting listings for final hearings for nearly 3 years, in 3 years' time. So the tribunals are absolutely jam-packed, and it will take 3 years to get to final hearing. There are obviously issues with that because some people can't remember what they did last week, never mind 3 years ago. So there's huge issues with the amount of time involved in a 3 year court proceeding. It's also incredibly stressful. Quite often, as small business owners, we are emotive. We see our team as family, especially if they've been with us for a long time. And it can have a knock-on effect on the rest of the team because they may have to be witnesses. You might have a 5-day hearing where you have to shut the practice for 5 days. So incredibly stressful. And also, it is incredibly expensive. So one of the issues we have with the employment tribunal is that each party bears their own costs. So what that means is, unlike in the county court, you have to be 100% sure that you win your case, because if you don't win, you have to pay the losing party's legal fees. That does not happen in the employment tribunal. So if you came to me today and said, Sarah, I'd like to instruct you to deal with an employment tribunal claim for me, you would be looking at somewhere in the region of £30,000 to £40,000 in legal fees. And you would have to pay that even if you won your case. This is quite often why we look at commercial settlements, because if the employee, even if you've done nothing wrong, if the employee is saying that they will go away for £5,000, my advice to you would be pay the employee the £5,000, because you're actually saving yourself £25,000 in legal fees. Some clients will say, no, Sarah, I want to pay you. I don't find it fair. And I will say, thank you very much. And we will go to employment tribunal hearing. Other clients will see the commercial value in it and will settle. Now, just a tip here. If you do not have legal expenses insurance in place, I would advise that you do get this in place. The premium is relatively low depending on how many employees you have, if you've had claims before, but you're talking a few £100s, and that will cover any out-of-court settlement, judgment and legal fees. So you will have an insurance product there which pays out if you do end up in the tribunal. So definitely something that all businesses should have. So termination. What are the fair reasons for dismissal? There are currently 5. Some people still talk about retirement, but retirement is not a fair reason to dismiss somebody. You cannot retire people anymore. But what you can do is dismiss somebody as long as you follow a fair procedure. And I never talk about what the fair procedure is, because it will depend on your business, and it will depend on how the employee reacts to what you do. So I can't say to you, this is step one, this is step two, this is step three, because the FAIR procedure doesn't work like that. You have to be reactive to the information that the employee gives to you. So the FAIR procedure does very much depend on the circumstances. But generally speaking, the 5 FAIR reasons for dismissal are: number one, misconduct. So this can be a series of misconducts or gross misconduct. To give you a case which I've dealt with in a dental practice where we dismissed somebody for gross misconduct is where they were in surgery, patient in the chair, and the nurse turned around and started vaping in the corner of the room. That was gross misconduct. Now, where people go wrong with gross misconduct is they are so aggrieved and so shocked about the seriousness of the misconduct that you may dismiss on the spot. However, you still have to go through a FAIR procedure. Capability. They're underperforming, and this is where the performance improvement plan really helps in terms of the procedure for capability. So it is quite prolonged, I would say. It can take some time when it comes to capability. If you want to dismiss, and quite often we will advise of a secondary route when it comes to capability, because it is quicker and easier, whereby you pay some money to the employee and in return they sign a settlement agreement. Again, you'd need to take advice for that, but that can be quicker than going through a 6-month capability process. So redundancy. We did a lot of this in the pandemic, not done so much of it with dental practices over the last few years, but this is where you do not have the work and you have a surplus of staff, or you're closing down a practice, for example. A legal reason, so for example, if somebody lost their GDC registration, if they didn't have the correct visa to work in your practice, that would be a legal reason. But again, you have to go through a FAIR procedure. And some other substantial reason, bit of a mouthful, SOSR. This is used when there are, for example, personality clashes. And the most common reason, or the most common scenario where I use this, is usually where there's a husband and wife team. Usually generalizing here, but the husband has an affair with practice manager, and the wife decides she can no longer work with the practice manager. That would fall under some other substantial reason. But for all of those, you would have to go through a FAIR procedure. And if you can prove that you had the FAIR reason and that you acted reasonably and went through a FAIR procedure, then an employee brought a claim against you, they would lose their unfair dismissal claim. Now, you can't bring those claims in the first 6 months now. So it's currently 2 years, but after the 1st of January 2027, it would be 6 months. So the 6 months is running. But what you can bring from day one is an automatic unfair dismissal claim. And this is in respect of discrimination, asserting a statutory right. So, for example, it may be that you start working in the practice, and as an employee, you decide to make a flexible working request. And then as an employer, you decide this person's a bit of a headache. They're already making a flexible working request to change their hours. I'm going to make sure they fail their probationary period. They would have an automatic unfair dismissal claim because they've tried to assert a statutory right. Whistleblowing, so protected disclosure. So to give you an example of this, there is a case of Matthew, who was a consultant cardiologist, and he made a disclosure publicly and internally about mixed wards in the hospital. He truly believed that it was putting patients' welfare and dignity at risk. He was suspended as a result. And because he truly believed in what he was saying, that patients' dignity and welfare were at risk, he suffered a detriment because of that suspension and could bring an automatic unfair dismissal claim. And health and safety. So again, if somebody claims that there's a health and safety issue, then and you dismiss them because of it or in connection with, then again, they can bring an automatic unfair dismissal claim because they have that protection from day one. So as soon as they start. So what's changing? In respect of unfair dismissal, we've spoken about probationary periods, but what you also need to be aware of is that they have removed, I say they, the people who produce the legislation, they have removed the cap for the amount of compensation that can be awarded in unfair dismissal cases. So ultimately, I used to be able to say to you, the compensation that an employee would be given in an unfair dismissal claim would be up to £180,000 in compensation, but now it's unlimited. So again, another reason to get legal expenses insurance in place, but also another reason to make sure that if you are looking at terminating somebody, that you do it fairly. So what are my top tips? My top tips when it comes to probationary periods, performance and termination is that you address the issues early. Don't let it fester. It's not good for you as an employer or manager. You become frustrated. It's not good for the rest of the team, but also it's not good for the employee because quite often they don't realise that there is an issue until it's too late. Keep accurate records. Um, we live in an age now where there's so many devices where you can record, that if you have permission and can record meetings, do so. If the employee does not want to be recorded, then make sure that you take a good note and keep accurate records. And also, my final top tip is to make sure that you take HR support as soon as you can. It is not easy. It's not getting any easier. The legislation is changing constantly. It's my full-time job to keep up to date with the HR and employment legislation. It's just one of the plates that you spin as a practice owner or manager. So you can't be expected to know whether you're doing the right thing or not. So it's very important that to be successful in terms of recruiting successfully, retaining the staff, and terminating the staff, that you do take HR support as soon as you can. So that's me. I am going to take some questions now. But that's our website, Instagram, Facebook. We try and keep you up to date as much as possible. You can contact us on those details there. And also, if you can scan the QR code, that will take you to our Google reviews and you can have a look at our reviews there. But also, if you would kindly leave me a review of this evening's webinar, it would be appreciated. But I'm happy to take some questions now.
Flip, that was great. That was great. We've got a couple of questions in the box. So the first one is, and I think you covered this actually, was are legal fees covered by practice insurance?
It very much depends on your insurance in terms of what you've taken out. So, for example, many people think that it's covered under employee liability insurance, and it's not. That's a different type of insurance that covers injury at work. This is legal expenses insurance for employment tribunal matters. And as a dental practice, you need to make sure that the product that's taken out covers your associates as well, because we have this funny structure whereby sometimes associates try and claim that they are employees, and what you don't want is the insurer saying they're not covered. You told me they were self-employed, so you do need to use a good dentally aware broker for that.
Fine. I misunderstood that one because I was thinking that's the legal, the insurance, the HR insurance that you can take because legal fees are covered under that, aren't they?
They are covered under that. Yeah.
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 Sorry. Yeah. So with the legal expense insurance, legal fees will be covered. Yeah.
Yeah. Brilliant. This one's this one. I think I'll ask the question, but I think it will be one that we could go on for the next 7 hours. Why have the government introduced these changes? Surely they know the impact this will have on the cycle of employment.
Well, what's interesting is I believe in the last cabinet they didn't actually have anybody that had actually been in business, did they? I think didn't have any business owners or in that last cabinet from what I'm aware of. So maybe they don't understand what it's like to run a business. Who knows? I don't know why there are so many changes to the employment legislation, but what it has been the biggest overhaul in employment legislation that we've seen for some time. So a lot of changes have come in this year and are continuing to come in. There's lots coming in on the 30th of October and into next year as well.
Did you mention the funny little, probably is the very derogatory term for it, but yeah, you mentioned that tribunals 3 years. There's something else coming in, isn't there? That's sort of like a quick fix tribunals or something. I can't remember what it's called now.
Yeah, so what came in April is the Fair Work Agency.
That was it.
So it's interesting one because what they've done is created this body whereby they have the power to come into your business, look at your records, to make sure that you are paying people correctly, to make sure that you are paying the correct notice periods, holiday entitlement, etc. So it's really important that your compliance is with HR matters is up to date. And it's almost people go, oh yeah, I pay correctly. I pay national living wage, but it's the mistakes that happen. So, for example, people don't go out and not pay national minimum wage. Yeah.
Hmm.
People, what they do is they think, oh, I'm going to deduct from their wage because they owe me some money because I paid for a training course, which then means their hourly rate
Below
falls
it.
below national minimum wage. So that's a huge mistake that practices make all the time,
Wow.
which means that they end up paying less than minimum wage. And this is the kind of thing where the Fair Work Agency can come in, they can fine you for doing that. They can also bring a claim to the employment tribunal on behalf of the employee, even if the employee doesn't want to bring the claim, and you have to pay their legal costs for doing so.
Hey.
So it's really interesting because if you go on their website, they're still recruiting. So even though they've been launched, they're still recruiting.
Wow.
And we just have to make sure that everything we're doing is in accordance with the employment legislation and that we've got records of it. That's what's important.
HR, whenever I listen, HR is just a massive nightmare, isn't it?
What would trigger a visit by the agency, Sarah? Is it kind of tipping off, or they just decide to wander in and never knows?
No, I think it's like HMRC. I think they can just decide to pick on your business and come in and have a look. What's worrying me, and why I think it's going to be so important for practices to have additional support in place, is because these people are not going to understand associates, for example.
Hmm.
So when they come into the practice and they say, "Why are you not paying your associates holiday pay?"
Yeah.
I'm going to make a claim on behalf of that associate, and it's going to go back 6 years for holiday pay you should have been paying.
Mm.
We're going to have to try and explain this to people that are not trained in this area. And this is why it's going to be important to have good associate agreements in place, understand the associate agreements, records of everything, and be able to explain to these people the structure of a dental practice. Because I do think that that will be something that they'll come in and look at.
And I suppose it's so
like in the early
important.
days of CQC, isn't it? When CQC first came, there weren't that many people with dental experience doing the inspections, and as time went on, they got better. They understood it more, and I think the inspections now it's much more a kind of collaborative approach.
It's probably about not being so helpful, and I don't mean that rudely, isn't it? And the danger is that as a business, as a principal, you try to be helpful because you think you're being helpful to HMRC, but I suppose there's a distinct risk that you say the wrong thing. And then you're in trouble. You're much better saying, "Oh, hang on a minute, I don't know the answer to that. Let me come back to you," or something, aren't you? I suppose it's that classic thing that I just imagine a lot of dentists are sort of like, "Yeah, no, I'll be really helpful. I'll be really helpful to HMRC, and I'll answer the questions," and they just say the wrong thing.
Yeah, the panic sets in.
Yeah.
We've got another question, Sarah, as well. Does the notice period depend on how long the employee has worked?
The notice period that they give you, no. So the notice period that you require from an employee or a self-employed member of the team, you can make a decision what that notice period should be, depending on your business, the commerciality aspect in terms of are they a specialist? Is it going to be hard to replace them? Are you in an environment where actually it's going to take you a long time to get a new team member in? They will want longer notice periods. The notice that you give to the team member when you're bringing their employment to an end, it is statutory, and it's 1 week for every year of service up to a maximum of 12 weeks. You can decide to give them more. I never advise that you give them more. Why would you? Unless it's a negotiation point and you're desperate to get that person in, and that's what they require from you. But ultimately, it's 1 week for every year of service up to a maximum of 12. And I would advise that you stay with what's set out in statute.
Wow. I'll tell you some of the things that I listened to that I've learned because we've worked with Sarah for a long time. Things like don't call someone a dinosaur. And bubbly. I always remember the bubbly one. People describe women as bubbly. You never describe a man as bubbly. I'll tell you the one that scared the Wattses out of me was 74. Was it 74 potential claims that someone can make on unfair dismissal? I mean, flipping heck, Tucker. It's huge, isn't it? Massive.
People don't realise that an employee or a potential employee can make a claim during the recruitment process. So you may think that it's completely free of risk to put a job description out there, to invite somebody in for an interview, to offer or reject the applicant, but it's not, because during that period, that person is protected from the discrimination legislation. Then they start on day one. There are 74 claims that that employee can bring on day one as soon as you employ them. And then it only increases the longer that they're with you. So and it goes on after they've left. So you might think, oh, that's it, they've gone. Whew, didn't like that one. Well, but afterwards, you've then got to make sure that you don't victimize them, and you can find yourself in hot water when it comes to providing references, because you might think, it's such a headache, I'm not going to provide them with a reference, but then they can sue you for your omission of not providing them with a reference. So it continues. That, in terms of the risks involved with being an employer.
And with no limit. I mean, you were saying it's gone from, what was it, 180 to there's no limit. I mean, it's just as an employer that we are, and as you guys are, and the people listening here, part of you says, why do you bother? And then the other part says, we all do it because we love it. But there is definitely something about making sure you're protected. And this isn't an advert for Sarah, but it sort of is. That you are, I think, if you spend all your time being a dentist, how in any way are you going to be able to be up to date with HR law? It's just not going to happen, is it? And you're going to trip over yourself. So I would sort of say, whether it be Sarah or someone else that I don't know, but Sarah is Buxton Coates' career profession. It's profession specific. So the danger is you'll go to someone else who Sarah mentioned earlier on. They don't know what an associate is.
Yeah.
So it's so important, I think.
Whilst they're in the minority, there are some people that make a career of this. They apply for jobs, they then put themselves in a situation so then they can take people to a tribunal. Are there any red flags or things that people can do right at the front end to try to weed out these people? And I know it's not most people are good. Most people, where it doesn't work out, it just didn't work out. They weren't cut out for the job or they weren't a good cultural fit. But there is this small minority of people who literally just bounce around trying to look to make claims. Are there any kind of common signs of those people?
Yeah. Well, first of all, my top tip would be don't use Indeed, because I think Indeed is just full of people who are out to see what they can get out of potential employers. And I can feel everybody who's watching go, oh, but I like Indeed. I get loads of applicants. But to me, it's like, why would an applicant in Leeds apply for a job in London? Why would they tell you, I'm a mum of four, and I'm looking for part-time work? It's when there's information provided to you. And what you've got to be able to prove is that you didn't make a judgment on that. And this is where the interviewing, training, and the recruitment process is so important, because we all have unconscious bias, because we all have different experiences that make us judge. But it's about whoever's doing the recruitment process making sure that we don't use those judgments, and that we can back up going back to the skill or our values and our vision that they didn't fit. And that's what it's about. And I feel as though it's definitely about the evidence trail. I think that's why I said one of my top tips is make sure that you've got accurate notes, because it might all be in here, but actually what's in here is probably a judgment. As if we can put it on paper that it was factual, that they didn't have that skill, we would be in a much better position. Um, Also, what I always say is don't provide feedback. So for people who are asking for feedback all the time, why didn't I get the job? What can I do better? This type of thing, in terms of before
Trying
you
to trip you up
employ
somehow.
them, I think you've got to be really careful with those as well, because you can end up digging a hole. And
Wow.
actually, the advice is it's the policy not to provide feedback. All the best for the future. That type of
We
approach.
got 3 questions, and I'm very conscious of timing. So, first one: how long after they leave can they take you to a tribunal?
Okay, so currently, 3 months less 1 day. Um, it is changing, of course, not to make it any easier for the employer, to 6 months less 1 day. So there's going to be a bigger window, for people to take the opportunity to take you to an employment tribunal, which is just in my mind opening the floodgates, because sometimes we'll get called up and it's quite straightforward. You're out of time. It happened a year ago. It happened 2 years ago. It happened 6 months ago. You're out of time. But actually, that advice is going to change going forward, because it's going to be 6 month window in which they get to bring a claim now.
Okay.
Do we need a personal improvement plan, even if we know very soon the person is not right for the business?
So when you say they're not right for the business, I take it you mean in terms of values, in terms of attitude rather than skill, because the skill is where the performance improvement plan really comes in. For me, if it's an attitude issue, I would be looking to dismiss quickly, because it's really hard to change attitude. You're not going to improve their attitude. But again, there's lots of questions here, because you need to think about how long have they been with the business? Is this something new? Is it early days? But you need to set out the expectation. So in terms of that person's attitude, have you actually set out what you're expecting from them in terms of this is how we all work together, or whatever it is that they're not quite attaining? We need to make sure it's very clear of that. You've got minutes that you've told them, you've given them the opportunity to improve, but I would say fire quick in those circumstances, subject to those conditions.
Okay. Next question I've got is where to advertise if not on Indeed?
Yeah. Depending on your privacy statement, I would say your patient database is one of the best places to advertise for a job. Your website, tell the staff. Definitely, people always try and hide it from the staff, but I would say they're going to be your best source of recruiting people. So try and stay away from Indeed if you can, because like I say, I'll really narrow the search down in terms of who can apply for the job if you can, because I feel as though it's very high risk.
Okay. Andy, do you want to do the last one?
Yeah, our last one. I think it's probably a recap just to make sure that everybody gets this. It says, is the employee associate notice period different when an employer gives notice to get rid of an associate or an employee?
So I think there's two elements to that. So your associates, who are self-employed, you can have whatever notice period you want on either side. So the engager and the associate, whatever notice period you decide. If they're an employed associate, you can ask for whatever notice is required and put that in the agreement. So 3 months, 6 months. As an employer, you have to provide at least 1 week for every year of service up to 12 weeks. The associate may ask for more. Whether you provide that is up to you. That's discretionary. So it does depend really on the relationship and what you're wanting to provide.
Brilliant. Thank you.
Yes, Sarah, so clear. It's a very, very complex area, and you navigate it and articulate it in plain English. It's very good.
Yeah, all I was going to say was if I'm assuming that a lot of the guys on the call are principals. If you haven't joined the Frank Taylor Principals Club, it's called the Principals Club. Type it in and Google it. Join. It's for free because Sarah is one of the experts, and as we have seen, she is the guru of HR, dental HR for sure. So join the Principals Club. Go and find it straight after this. Have a little Google, click and join, and you will read some of the articles that Sarah has produced for us, and we'll have all her contact details. And Sarah is really happy to have an initial conversation with you. We can even join you in our WhatsApp group, and Sarah's part of that. So if you haven't joined the Principals Club, please do, because Sarah is an expert.
Chris, just to add to that, one of the things I did for the Principals Club was a chart of the legislation that's coming in April. So I know we haven't touched on a lot of it this evening, but I think it's really important as a principal that you are aware of what's in force. And when I'm speaking to practices, they're not aware of all these changes, but there's a very straightforward chart at the Principals Club on the website, which you can go to, and it gives an overview of everything that's changed, so you can see if you're up to date.
That's superb. Thank you for that. Yeah, I say so. Join the Principals Club, and you'll be able to have access to that for a starter. I don't think I've got anything else to say apart from the fact it is amazing. I don't know how long have we been doing seminars, webinars with you, Sarah? 10 years, 15 years? Even though you're too young, but at least 10 years. And I tell you what, the pace of HR change, every time I listen to you, even if it's only a couple of months in between, things have changed in that short time frame. And I just think that anyone running a business, they're stupid if they don't engage HR expertise, because it's more luck than judgment that they won't make a mistake. And I think, as you said, the legislation is just getting more and more stringent. So therefore, you need to have expertise on your side. Yeah. I'll just say thank you very much. Brilliant.
Let's see what happens now with our new PM as well.
Yeah, definitely.
The pace of change won't slow down for sure. No, thank you, Sarah. That was really good, really enjoyable. Thank you everyone who joined us as well this evening.
Yeah, thank you. Have a good rest of your evening. Get a cup of tea and go and sit in the garden.
Thank you.
All right,
Cheers.
cheers. Bye.
Bye.
Cheers.